The GDPR represents a significant evolution from the previous framework established by Directive 95/46/EC. The primary objective of the GDPR is to ensure comprehensive protection for the rights of data subjects in the EU, as well as to establish a level playing field for companies active in the EU market, reflecting the modern reality of global data flows. Key principles on territorial scope of the GDPR. Establishment criterion. Article 3(1). The GDPR applies to the processing of personal data in the context of the activities of an establishment of a controller or processor in the Union, regardless of where the processing takes place. Targeting criterion. Article 3(2). This criterion extends the GDPR's reach to controllers and processors not established in the Union, but who target data subjects in the Union by offering goods or services or by monitoring their behavior. International law. Article 3(3). The GDPR applies to processing when member state law applies by virtue of public international law. Representatives of non-EU entities, controllers or processors not established in the EU, but engaging in activities that fall under the GDPR, are required to designate a representative in the Union. Application scenarios. Establishment criterion. The notion of establishment implies effective and real exercise of activity through stable arrangements in the EU. The presence of a single employee or agent may constitute such an establishment if their activities are sufficiently stable and contribute to the controller or processor's EU activities. Targeting criterion. This criterion focuses on activities directed at data subjects in the EU. The GDPR applies regardless of whether the subjects are EU citizens or residents, emphasizing the regulation's focus on data processing activities rather than personal attributes. Processing in places where member state law applies. The GDPR's application extends to controllers or processors operating in places where member state law applies by virtue of public international law, such as embassies or consular posts. Representative of non-EU entities. Non-EU entities subject to the GDPR must designate a representative within the Union. This requirement underscores the GDPR's goal to ensure compliance by entities outside the EU that engage in processing activities affecting data subjects within the Union. Conclusion. The EDPB Guidelines 3/2018 clarify the territorial scope of the GDPR, ensuring its application is comprehensive and consistent across various scenarios involving data processing activities that affect data subjects in the EU. By outlining the establishment and targeting criteria, as well as the requirement for non-EU entities to designate a representative in the Union, the guidelines reinforce the GDPR's aim to protect personal data and establish clear compliance expectations for entities operating both within and outside the EU.